Welcome to our webinar presentation on landlord prep, COVID-19, tenant eviction, and rent deferral moratoriums. I'm Michelle Chen, one of the organizers of our monthly Santa Clara County Landlords Mastermind, along with Jane Lee and Sean Pinello, who will be sending you the slides and maybe some follow-up information. So don't worry about taking too many notes. These slides will be emailed out to everybody along with some additional information. I am also a real estate advisor helping landlords take a closer look at their real estate portfolios to increase and sometimes double, triple, or quadruple their annual cash flow incomes. So the goal of our monthly webinars is to bring more awareness and education to our California landlord community. Since we are all online now due to shelter in place, I know we have many friends joining us from all over California, not just the Bay Area. So I want to take this time to thank you so much for being here with the mindset of staying current, learning, and becoming more prepared in this difficult time with this 1 hour webinar, even if we have all this crazy stuff going on. So I really appreciate your time in being here. So before we dive into the main topic, I'm actually going to invite our very own Lisa Doyle from the East Bay Real Estate as a East Bay Real Estate Specialist to give us a quick market overview on what she's seeing in the residential market currently and share some insights as to what we might see in the next few months to come.
So thank you so much, Michelle, for having me. Always happy to help. I always love working with you on all the different ways that we get to work together. So we have had so many questions from clients all over the state, actually from all over the country, because a lot of our investor clients, of course, live other places and they own property in California. So people are asking questions all over about what's going on with our market and where are we headed. So that's a good question, and we do not have a crystal ball. But what I will share with you, and we'll go through some data together, and I'm going to give a quick overview of our, basically our East Bay kind of Northern California market. And I watched the whole state real closely as well. Is the market in the first 2 months of this year had gotten very active, very hot. Interest rates had come way down, as most of you probably are aware. Demand for housing right now is still very, very high from what we can see. So there's a lot of pent up demand. The first quarter, like the part where we weren't shelter in place. Lots of demand for housing and buyer needs still strong. So here's the first slide I want to share with you guys. We keep in touch with some very knowledgeable economists, people I've counted on for years. I've been in the real estate business for 34 years, and we've been through every single possible change you can imagine, from high interest rates to crashing markets to adjustments to all of it. And what they're saying, and that they have always been spot on with how the market progresses after an incident. So take a look at the first graph as far as the Goldman Sachs GDP forecast. They're obviously anticipating Q2 is going to be a little rough. I mean, we're already into Q2, all the country, working very hard to get through this process. What they're sharing, though, is that this point in time is likely to be a pretty quick bounce back, similar to other times where our country has been impacted. 9/11 being one where we recovered very quickly, but they're anticipating Q3 and 4 and into next year that this strong high demand for housing will continue, and interest rates are likely to stay very low, which has been fueling our market right now. So this is a positive outlook on where we would likely go, and we don't have a crystal ball, Michelle. We don't know for certain how the market will progress, but I would propose that this resource, I've kept in touch with an economist, Steve Harney, who's the person who he and I had a meeting last week to go over this data. So let's look at the next slide as well. This will give a little bit of positive encouragement. So what we did was we went back to all of the times where our country has been impacted, the stock market impacted by other parts of the world, suffering through, pandemics similar to what we're all seeing right now. And the amount of time that it took for us to recover was actually quite quick. We realized that our country wasn't as impacted in these times as we are today, but the same data holds true. If you look at the trading days, how long it took for our country to bounce back from negative, downfalls in the S&P and the stock market, 38 days, 141 days, 43 days, 23 days, and 66. So we've recovered very quickly from previous issues that are similar. And I went back to the stock markets in these other countries, and they experienced the same type of recovery. So it's we're not likely to see this last as long as you might say with what we saw in 2008. So I know, Michelle, you've had a lot of these same questions as well as people wonder, is this adjustment that we're going to be experiencing after the shelter in place opens, is it going to feel like a 2008? And I don't have a crystal ball for sure. What I can share is what we've been studying on what caused 2008 to occur versus what we're seeing today and in the future of this year. Switch to the next slide, Michelle, and I'll go through some data. So Steve Harney, again, he owns a company called Keeping Current Matters, a very knowledgeable economist. He went through some data with us to share with us why today is not like 2008. So if you look back at 2008, what was occurring with people's equity, the average home in our country had less than 15% equity at that time. Today, over 50% of the homes in our country have more than 50% equity and 20% are free and clear. I think we've all learned from the past as far as our homes, and less people are using their homes as debit cards and taking their equity out for things that back then people were using them for home improvements. They were using for vacations, things like that. Something else that's super impactful is today's home mortgages across our country. Back in 2008, the total debt on homes in our country was over $832 billion. And today, even though this appears to be a high number of significance compared to then, we are only at about 365 billion as a country as far as debt that we owe on our homes. So, and then lastly, our loan practices have changed so dramatically in the last 10 years. Average consumers today are putting 20% or more down payment. Back then, we saw consumers buying homes at interest rates that they couldn't afford, negative amortization loans, and buying homes with over 100% of debt. So what I would share with you is the data supports a recovery that we shouldn't be seeing a long, dramatic, negative effect on our real estate. I'm optimistic to think we're going to bounce back from this pretty quickly.
Awesome. Thank you so much, Lisa. Thank you. For everyone who might have some burning questions for Lisa, we are asking that if you could please save any questions to the very end. We will have a 10 to 15 minutes Q&A that we are probably thinking about expanding. So at the end of our presentation, now without further ado, I would like to introduce David Bonacorsi, who is a partner with the law firm of Bernard Bagley and Bonacorsi LLP in the Bay Area. Dave, please take it away.
Good morning, Michelle. And thank you, Lisa, for such a positive start to the meeting. There's light at the end of the tunnel. Yes, my name is Dave Bonacorsi. I've been practicing law for 32 years and was also formerly on the Fremont City Council. So as we approach this moratorium, I understand some of these issues, both from a legal perspective, but from some of the policy perspectives that these issues are going to raise as we go through. And so, Michelle, if you could move to the next slide, please. There we go. Since we've had a declaration of an emergency by the governor on March 4th, there's been a series of things. It's been very fluid. Michelle contacted me about a week ago, and there's been some significant developments in the last week that have changed the presentation I was about to give. So when we're learning what the rules are for landlords and for tenants, we need to listen to the governor, the counties, and the cities. The governor stepped in, and I'll talk about that in a minute. And then I'm going to be talking a bit more about what the California Judicial Council or Judicial Commission did just last Monday that's changed the landscape entirely. Next slide, please. On March 4th, Governor Newsom declared a state of emergency, an SOE declaration. That's going to be very significant when I talk about what the California Judicial Commission did, because it's going to set some important time frames for what landlords frankly cannot do for some significant period of time. Then on March 16th, the governor had another executive order which allowed cities and counties to enact eviction moratoriums and allow for deferred rents for residential and commercial tenants. This was otherwise, or previous to this, cities could not regulate in this area, or counties could not. So this executive order was very significant. Next slide. What did it do? It opened the floodgates for moratoria up and down the state. And some of the counties that have stepped into it is Alameda County, but it's only to this point enacted rules for residential property, but not commercial, and only in unincorporated areas. Santa Clara and San Mateo County have both enacted ordinances that apply both to residential and commercial tenants and leases. And very significantly, it applies not only to the counties that are unincorporated, but to the cities within those counties. Normally, counties only regulate unincorporated areas. But because there's significant public health and safety issues involved, there's special powers that the counties can rely on to expand their authority, their jurisdiction over regulating cities. Next slide. These are some of the cities. I was focused on the Bay Area. You can read them yourself. But that we have people in LA, and there's certainly an ordinance that's in effect at least for a couple more weeks down in LA. Next slide, please. The governor then, after he allowed the cities and counties to act, stepped back in again and said, for those cities and counties that do not have any ordinances at all, we're going to give minimum level protection to tenants. And if they give a 7-day notice saying that they're sick, laid off, reduced hours, childcare, or school closures related to COVID-19, they're going to be entitled to not have to pay rent. But they must have been current on the rent as of March 27th. Next slide. Tenant must retain the documentation, but need not show it until the back due rent payment is due under the governor's executive order. He really doesn't provide for how payments can be repaid, but it's a good idea to ask for the tenant to provide it. But if they say no and they're invoking this executive order, they don't have to until their rent is due. There's a limited tenant benefit, and since the California Judicial Commission has stepped in, it really has become irrelevant in my opinion. Next slide. No writ of possession may be enforced for landlords that are used to getting their unlawful detainer complaints filed. At the very end, if you get a judgment, you get a writ of possession that the county sheriff enforces. Well, again, I'm going to talk about why that's not relevant going forward. And most counties, I know for certain Alameda County, I suspect Santa Clara and San Mateo, the county sheriff said if you got a judgment before we went into a shelter emergency or state of emergency, we've got other priorities right now. We're not going to be enforcing these writs and vacating tenants. The governor's executive order expires May 31st, and we'll have to see what he tries to do after that point. Next slide. This is what I call the game changer. If there's nothing else that you remember from today's presentation, this is really our starting point now, and this just happened on Monday. The California Judicial Commission is this statewide organization that oversees the administration of our courts throughout California. Even attorneys are not really familiar with what it does. We know that they have rules that they issue, but I've never in 32 years of practice have ever seen them issue emergency orders. And so it's chaired by our Chief Justice of the state of California, and the members voted unanimously to enact these rules for every court in every county in the state of California. No summons for 90 days after the state of emergency is lifted. So if you understand that when you have your 3-day notice to pay rent or quit, the tenant doesn't pay rent, you then file your lawsuit, they either answer and you have a trial, you win, but you can't serve that lawsuit unless the court clerk issues a summons. That's a special document. So because the Judicial Commission has authority over the courts, they're telling all the court clerks, you are prohibited from issuing a summons. And if you're prohibited from issuing a summons, you cannot begin your eviction proceeding for 90 days after the state of emergency is lifted. When's the state of emergency going to be lifted? I don't know. I'm just based on what I'm hearing from the CDC and from Governor Newsom flattening the curve in California. I'm looking at maybe July or August before the state of emergency is lifted. And what does that mean for you? You're looking at maybe November or December for tenants that haven't paid rent before you can even begin the process for going back into court. So yes, there's going to be a bottleneck, but it won't be until November or December. And I've represented landlords, and under the best of circumstances, it can take 30 to 50 days or more to get to the point where you get a judgment and an eviction if it's a contested case, if they don't file bankruptcy and delay it further. So again, the huge takeaway is no matter all these rules that we're going to look at today, at the counties, at the cities, they're all very nice and they must be followed, but you need to begin to take a deep breath and realize there's going to have to be a long view in terms of enforcement if there are tenants that don't play by the rules. Again, no entry of default for 90 days. Well, that's kind of irrelevant because you can't get a default because you can't get a complaint. But let's say you'd filed a complaint, the answer had not been filed right before the courts closed, and you had ready to be entering a default the first day the state of emergency is lifted. The court said, no, you got to wait another 90 days. Trial settings. If you had a trial date before, not only has it been canceled during this closure of the courts, but it's going to be set at least 60 days later. Now, there's an important exception here. Rare, but you got to look out for it. Let's say you have a tenant that is engaging in criminal activity or doing something that is endangering public health and safety. Create a record of that, deal with law enforcement. That's a high priority item. When the state of emergency is lifted, at that point, you can go into court and say, Judge, I need a summons now. I need a trial date sooner. I need to get this tenant out of here. It's a notice motion. There's a hearing. It's unclear whether the tenant needs to be noticed, presumably for due process. They're going to be contested, but if you get it granted, you might be able to shorten those times. But 99% of the time, you're not dealing with public health and safety issues. You're just dealing with rent. These emergency orders will sunset 90 days after the state of emergency is lifted, or if the California Judicial Commission repeals it or amends it. Next slide, please. What now after these emergency orders? Again, I had these questions and I was going to do this granular analysis before the orders, but everything now has to be seen in light of this significant change to the ability to even get into court for renters that have not paid rent. But just generally, what do moratoria do? And I'm getting general questions, and they may be difficult to answer because it's always going to depend upon where you live and in the state and what ordinances may be in effect. But generally, eligible residential and commercial tenants can defer rent. That's what all moratoriums try to accomplish. Most eligible tenants' leases cannot be subject to termination. So if a tenant gives you the required documentation, gives you notice that they can't pay, and under the executive order, they just have to give you a 7-day notice and not show you the documentation, you really should not begin trying to do 3-day notices or 30-day notices. And because that's the window period or the safe harbor that these tenants are being given. The moratoriums that were enacted before Monday have special rules delaying eviction proceedings. But again, the state rules are the most aggressive under the California Judicial Commission that really they've rendered a lot of these moratoriums on when you can start an eviction proceeding irrelevant. And significantly, a lot of the moratoriums try to distinguish between small commercial tenants and large commercial tenants. For example, Fremont has an ordinance that says we're going to give commercial tenants the right to claim rent forbearance or rent deferral as long as their gross receipts are less than $8 million per calendar year. Well, under this new CJC order, it really doesn't matter whether you have a large commercial tenant or small commercial tenant. You can't evict them regardless of their size. Moratoria really now creates two classes of tenants: eligible tenants who can defer rent, and ineligible tenants who fail to apply or qualify who can't defer rent and may be subject to some pre-lawsuit termination notices. But again, we'll get into the implications of the California Judicial Commission orders. Next slide, please. For tenants who are ineligible, you can serve pre-termination notices, but I'm going to say why. Okay. If any of you, typical situation where you've got a tenant, you give them a 3-day notice, and on day 5, the tenant comes to you with a check, says, well, here's my rent, I'm a little bit behind, and you cash it. Okay, if you cash it, you've waived your 3-day notice, you have to start all over. So you can feel really aggressive now and say, I'm going to hold firm to my 3-day notice. And if it's under the new state law, and I've had a separate presentation that Michelle's seen under the new state law, under AB 1482, which is Rent Stabilization or a Tenant Protection Act statewide. If it's subject to this new law, you have to give a 3-day period to cure and then a 3-day notice. You can be really aggressive and say, let me get my process server out there and do it. And then what are you going to do? Sit there and not accept rent at all in order to keep that, preserve that right so you can go into court 90 days after the state of emergency is lifted? You know, this is really an important business decision for you. And I think as we go through, this is really going to try to spur a conversation with tenants in good faith, try to get some income stream going and not try to be overly aggressive on evictions, because it's only going to hurt you. Tenants will never be able to catch up and you're never going to be able to collect the rent, likely ever. There is certain rules, I'm not going to go into them here, where you can get a partial rent accepted from a commercial tenant if you do the right notice. But again, why do it on the front end if you're going to have to wait until 90 days after the state of emergency is lifted before you can even file a lawsuit? Next slide. What now after the orders for residential tenants who are eligible? These are questions that you need to ask. I'm not going to go into them too closely because there's too many variables. But you may have a city moratorium in the same county as the county has a moratorium, and but if you have neither for residential tenants only, then the governor's executive order that I described will be the only protection that residential tenants have. We're in urban areas, most of us that are calling in. Although I think Contra Costa County has been less aggressive so far on moratoriums. I'm only aware of Concord. Maybe other cities are stepping up. So if you're in Danville and in San Ramon, I heard some people checking in. There may be just the executive order from the governor, although it's changing week to week. If no city but not county, then compare the executive order to see whichever favors the most favors the tenant. If not the city but in Santa Clara, San Mateo counties, then you just look at the county ordinance and compare it to the state executive order. And then if both the city and Santa Clara and San Mateo County, for example, compare a city, county, and executive order, don't worry about it. You really should consult an attorney. I've got some practical thoughts on the matter. Next slide, please. What now for commercial tenants? Again, this is the same discussion, city and county. But again, the governor hasn't stepped in, so you're going to just be comparing whether there's a city or a county ordinance. If there's no ordinance at all for commercial tenants, and some cities have enacted for residential tenants but not commercial tenants, then you're free to do all the things in terms of not allowing the commercial tenant to defer rent. But again, I'm going to ask you why you're going to do that in terms of trying to give 3-day notices and 30-day notices when you can't get in the courts for another 6 months. So again, number 2 and number 3 are really comparing which ordinances are in play. The rule is when there's a conflict between, and this is true for residential and commercial, when there's a conflict between the ordinances, the one that favors the tenant the most is the one that needs to be applied, and it can go provision by provision. Next slide. I wanted to talk about Santa Clara County because we are in Santa Clara County, and this is just a representative example of a moratorium that's in place. Again, it's similar to the executive order that we saw earlier from the governor, and it's similar to many ordinances at the city or county level. The tenant must document some COVID-19 related substantial loss of income, either because of job loss, layoffs, reduction in work hours, foreclosure, care for the COVID-19 affected family member or child, or obviously if you're ill yourself. And then in that instance, you can show substantial out-of-pocket, the tenant shows substantial out-of-pocket family medical expenses, then they're entitled to eligibility. Again, eligibility means that they have the ability to defer paying some or all of their rent until the lifting of the ordinance, in this case, which is, I believe, May 31st. Commercial real property in Santa Clara County, they have a definition of small business, which is far more expansive than Fremont's, for example. Fremont, as I said, limited to commercial tenants that have gross receipts of no more than 8 million. The commercial real property definition of a small business goes to the Small Business Administration's table of size standards in the Code of Federal Regulations, and that's really not very clear in my opinion. And I'll talk about an example. I was representing a client on Monday. I shared with Michelle, I hope she got it, my letter that I sent to the city of Gilroy on this, because it depends upon industry sector and number of employees. And I was looking at some small businesses that could have receipts of as much as $27 million or more per year. LA, for example, has a restriction on commercial real property that if you have more than 500 employees, you're out. If you're publicly traded, you're out. So they have different definitions. There's an attempt to differentiate in these ordinances between small and large businesses that might be eligible. Santa Clara County moratorium is to be credited by providing some guideposts. I think this helps landlords and tenants. The deferral can be up to 120 days after the current May 31st, 2020 expiration of the ordinance, or if the ordinance is extended, and it likely will be. But there's rules that you got to give notice of the tenant's rights when you serve your notice of termination, and provide them a list or a website link to rental assistance, and you have to provide a copy of your notice to the in San Jose, for example. If it's under the city ordinance there, you have to actually provide a copy of your ordinance to the local housing authority. A lot of rules, a lot of regulations you have to file. Again, if the tenant is eligible, it voids no fault or non-payment termination notices. So we think in terms of non-payment, but there's also, it voids no fault evictions. And under AB 1482, for example, there is now an exception for a no fault eviction if you have a family member that wants to move into investment property that you own. You can evict a tenant there, and say you had a son, he was in his 20s, wanted to move home, but because of COVID-19, you kind of wanted to create a longer term solution. You could begin eviction proceedings there. But again, you don't have access to the courts, but theoretically you could begin the no fault proceeding there under AB 1482. But if the tenant says, hey, look, I've got a COVID-19 related issue, you can't begin the no fault process either. Next slide. This was a question as I was going through, and I'm going to be more interested in the questions I hear from you, but this is something to think about, or really for attorneys to think about when you seek representation. Which is more tenant friendly for a tenant claiming and or documenting eligibility for rent deferral? Santa Clara County ordinance or the governor's executive order? For purposes of today, I'd say just follow the Santa Clara County ordinance as long as it's in effect, because you're going to be going at some point to the Santa Clara County courts, and you don't want to be sitting there arguing which rules apply. However, if a tenant is shrewd and claims that they're just giving you a 7-day notice and they don't have to provide you documents, there may be a way of harmonizing both of those, but this is not a time to play gotcha. And let me step back before I get into the Q&A. I've got one or two more slides. The idea of unlawful detainers is in the area of litigation or access to the courts. Unlawful detainers historically been given a priority position over all other civil litigation. By court standards, it's a rapid process. If you've been a landlord, it may seem like it's taking forever to get your tenant out. But relatively speaking, you get to trial faster, you get a resolution. If you prevail, you then go to the county. That can take county sheriff, that can take another 2 weeks if the tenant hasn't vacated. Why? Because you have property rights generally, okay? And you've given away your right to possession to a tenant. A tenant who has not paid their rent is now unlawfully detaining, but you can't take self-help. We're not in Texas. You can't just change the locks. You have to go through a court process. So the balancing historically has been to allow landlords who have legitimately asserted their rights to reclaim possession because of a default in the lease or default in rent, that they have a right to recover possession. But you're going to say, this is so tenant friendly. Everybody's rolling over for the tenants. The effect is yes, and some are doing it, particularly with local ordinances, to satisfy local tenant advocacy groups. But I think as we think through this process, let's all step back and say there's another reason why this is happening. COVID-19 is a significant health safety issue for all of us. And what the state's looking at statewide and what counties are looking at and public health officials are looking at is ways of minimizing tenant displacement. So if you had tenants that simply vacated and had nowhere else to go, they become more of an infection risk for all of us. So it may not feel very good, and I understand there's a lot of stress, and you've got to make mortgage payments yourself, perhaps some of you, and you're going to have tenants there, they're going to game the system. I understand that. But if for tenants that are acting in good faith and landlords that are acting in good faith, there is a larger issue where we are all in this together, at least as long as the emergency orders are in place, to try to minimize the risk to all of us of the public health risk of displacing tenants that are really out of work or are caring for somebody that has COVID infected tenant or family members. So, again, that doesn't maybe give you the comfort you want, but if you look at it through that lens, it may be less adversarial than saying, well, the tenant's getting a gift. Why are we giving the tenants, the keys to the store? It's really a public health issue for now, and that's why the counties have, at least in Santa Clara and San Mateo, have been able and are authorized to enact stringent ordinances that apply to the cities, as long as the cities don't have ordinances or if the cities' ordinances are weaker, because you can't divide COVID-19 up between cities and counties. It affects the region simultaneously. Next slide, please. We're going to go and look at some sample forms. This is in Santa Clara County. And this, again, tracks the ordinance that was enacted by Santa Clara County. And you have to, this is a notice that is a sample form from landlord notice to tenant. So you have to state the reason why you're trying to evict. You have to do that in addition to your typical notices. And of course, if you're in a rent stabilization city or rent control city or subject to AB 1482, you're going to have to follow those rules too. But this is in addition to any of these notices: a notice of tenants' rights under the ordinance, a notice of emergency rental assistance programs. This is the top half of the slide, so you could see it of the form. If you could show the bottom or the next slide, please. Yes. This is the sample moratorium in its entirety, and it explains the entire form that is to be given for attempted evictions in Santa Clara County. And if we can go to the next slide, please. This is what the tenant's going to come back in response, either in response to the 3-day notice or ideally, from the tenant's perspective, to do it before he gets a 3-day notice or a no-fault eviction notice. And if you look down about 2/3 of the way, it says COVID impact. My income has been substantially negatively impacted by COVID-19 due to the following. And you can, and the tenant can check all that apply, and it could be more than one, and so if they give any of those reasons, those are all legitimate in order to be able to stop the eviction process, to be able to defer rent. And you're going to say, well, any tenant can fill this out. How do I know? It's a good question. At least right now in Santa Clara County, the tenant is encouraged to provide documentation, and really you should request documentation from the tenant. And these are the examples of kind of the documentation you can provide. But if you look at the last box, documentation for items selected above is attached. There's a yes or no, because frankly, the ordinance does not in Santa Clara County explicitly require the tenant to provide that documentation. As you recall, and I'm giving you a lot of information, under the governor's executive order, they could provide that up to the date that the back rent is due, some point 120 days from now or whatever that period is. In Fremont, they do require you to provide that documentation, and it's within 5 days of when the rent is due. You have to provide specified documentation in the Fremont ordinance. And how do they communicate that to you? It's really interesting to see how some of these jurisdictions are trying to deal with the reality of shelter in place and how we're communicating when we're not really supposed to be handing documents to each other in person because of social distancing. So in Hayward and in Fremont, for example, there's I think it's a very common sense approach. You have to do it in writing. Well, in Fremont and Hayward, you can do it in writing as simple as a text with attachments or emails with attachments, but only if the tenant and the landlord had already, before COVID-19, communicated that way. So they're trying to minimize things where you have to physically mail or physically personally serve documents to each other, and people may be far away. If you have a corporate landlord, the property manager may not even be on site right now, or you have to deal with the corporate headquarters somewhere out of state. So these are things that are practical that some of these ordinances are trying to address. The next slide, please. This is really where I think a lot of the discussion may end up being today, or we're going to think about. I'm going to tell you something that's not going to make anybody happy. How about that for foreshadowing? The state legislature will step in, I'm sure, in some manner. It can step in a positive way, and I'll tell you what I think would be positive. But just this week, Assemblymember Ting has introduced, I think it's called AB 1828, AB 1828. And if this somehow passes the Assembly and the Senate and signed into Governor Newsom, it would reduce rent across the board 25%, flat across the board, statewide, for up to a year. So even, so it's going to create a situation where if you're trying to work with your tenant, maybe they're going to pay you 80% or 90% of the rent or whatever it is. It's a kind of top down. I haven't seen the legislation, but I know that the Rental Housing Association is really opposed to it because it's kind of a hammer and it's a one size fits all approach that really doesn't allow for flexibility. A better way for the legislature to step in, and I really think this was behind what the California Judicial Commission was doing, was saying with the 90 days after the state of emergency is lifted before we get into court, that's more than enough time for the Sacramento to step in, and maybe the governor, but ideally legislation signed by the governor as opposed to governor's executive order, setting uniform standards for rent deferral and rent repayment. And so you're not doing what we just went through and saying, okay, I live in Mountain View. I know Mountain View's got I've got property in Mountain View. I know Mountain View's got a local ordinance. I got to compare it to the Santa Clara County ordinance. And then maybe the governor's executive order. It's just patchwork right now. It's crazy. I do think Sacramento has to step in and perhaps take away local control again from these eviction rules because everyone's coming up with their own rules. State, county, or city action to impose rent forgiveness. That's beyond deferring rent, literally saying, okay, during this crisis, whatever rent you would have owed for 90, 120 days, poof, it's gone. It's forgotten. San Jose on Tuesday had that on its agenda. It had an 8-hour city council meeting on Tuesday. They put it to the very last because they knew there was going to be a lot of public comment, and maybe they were going to try to outlast everybody. At the very end of the evening, they tabled it. They didn't deal with it, but it's going to come back up. So you're going to have to look at your own cities to see, or counties perhaps, to see efforts to literally forgive rent. But let me tell you what's happened even this week. I've got two examples. One is in Gilroy. I represented some large commercial landlords. They hired me on Monday, and I had to write a letter to the Gilroy City Council on Monday. They had a definition of small business, which was that SBA standard, and they had tenants that were large businesses by any other means. I was trying to get them to enact the $8 million cap that Fremont had as an example of really keeping it to small business. Well, when the council was considering it, was a second reading. They had originally passed an ordinance on March 24th, And anybody that's ever followed a council meeting or seen whatever happens at a council meeting, whenever a council passes an ordinance, they have to have two readings. One is adopted, and then the second time it's usually, rubber stamp. They adopt it after the second reading because the state law requires two readings. Rarely, if ever, does anything change in the second reading. Well, in light of what had happened on Monday, and by the California Judicial Commission, because of the Santa Clara County ordinance, because you can't get reports, one of the council members, it was a 4-3 vote, she shifted her vote. She says, we don't need an ordinance anymore. The county will take care of us, and the state's already taking care of us. So that was one response to what the governor did. They took away the local moratorium because it made no sense. The county of Santa Clara takes care of both commercial and residential tenants, and rather than having conflicting rules, let's just have the county rules. That was one response, and I thought that was, from a policy perspective, pretty sophisticated response. For my client, it didn't help because the county rule, unfortunately, for what is considered a small business was exactly the same as the ordinance. So it never occurred to me that they would abandon their ordinance, but we still have the same rules now emanating from the county as opposed to the city of Gilroy. Another response was Hayward. Hayward on Tuesday repealed its own prior ordinance and made it tougher and expanded it not only from residential, but now includes commercial, and it even includes lender evictions for mortgages. Why did they do that? They issued a press release yesterday that says explicitly because of what the California Judicial Commission did. Since you can't get into courts anyways, we're not going to worry about whether you're a large or small commercial enterprise. We're just going to have a blanket prohibition on evictions because that's the reality anyways. And you can be a large business and claim the benefits of this ordinance if you can show a substantial loss of income. We're not going to make fine-tuned distinctions. And this is a very interesting reason. Why did Gilroy go to the Santa Clara County ordinance, and why did Hayward, frankly, double down by expanding commercial eviction prohibitions? If you recall at the beginning, I mentioned that Santa Clara County has an ordinance that does two things. One, it applies to the entire county, so it applies to the city of Gilroy. And secondly, it has both a restriction on commercial as well as residential leases. Let's go back to Hayward. Hayward's in Alameda County. We have a relatively weak county ordinance that only applies in unincorporated areas. It doesn't apply to the city of Hayward and only applied to residential, but it doesn't matter. It doesn't apply to Hayward. So Hayward has the ability to regulate its own city without interference from the county. And so it doubled down and expanded it in light of what had happened on Monday with what I call the game-changing rule emergency orders from the California Judicial Commission. Look for when the shelter of emergency is lifted, because that's going to start the clock for getting back to the courts, unless the California Judicial Commission changes its orders and shortens the time or does something different. Again, I'm not an epidemiologist or virologist, but I would suspect that we're looking at July or August before the state of emergency is lifted, and that's when the 90 days starts ticking before you can go into court and try to file an unlawful detainer complaint. There is also, I'm not a mortgage broker. Talk to your mortgage broker, and perhaps Michelle's organization can help. There is some landlord relief out there if you have a Fannie Mae and Freddie Mac loan for multifamily dwellings, that they're going to give rent forbearance. And even if you don't have a formal program, contact your bank, contact your lender, and see if they're going to give you rent forgiveness too, because you're not getting it from your tenants. So it may have to go up the chain. But my bottom line, it's almost 11:45, so I think I've timed this pretty well for the 15 minutes on the 1 hour. I think that we have to be adults here. Again, there's going to be a certain bell curve where a certain percentage of the tenants are going to take advantage of this and be unreasonable, and you're going to say, what can I do? How can I do it right? Those are the difficult situations. I'm hoping that a broad sweep of the tenants and a broad sweep of the landlords will honor the difficulty that we're in and have workout orders and maybe accept some pay and have a relatively tenant-friendly repayment schedule, because I think at the end of the day, it's not the tenant wins and the landlord loses. You're far better off having a continuous income stream rather than having to go through the process that is so far out to evict that tenant and try to find a replacement tenant. That may not happen until January or February of next year under the best of circumstances. So you're in it for the long haul. How can you best keep up your income stream during this period of time to get to that soft landing, as soft as possible? So try to build relationships with your tenants. This is not a time to play gotcha, because if you play gotcha, some of the ordinances are going to really sting you. Like in Hayward, they can sue you and get emotional pain and suffering and $1,000, whichever is greater. So you don't want to be in court defending efforts potentially in your jurisdiction for trying to play hardball here when you stepped over the line. So try to work it out. That's how we'll conclude right now, Michelle.
Sounds great. Thank you so much, Dave, for that very informational presentation. So what we're going to do now is open up for a quick Q&A session. Please go ahead and open up the Q&A box and send in your questions. I know, with Dave's presentation and the information that's shared today, everybody's situation could be different, right? And so we can offer a personal solution with a follow-up meeting or anything like that, with our contact information being mailed out, and also the slides will be mailed out as well. This webinar has been recorded, so if you feel like any members who might not have been able to make it to our webinar today, you feel free to send that recording to them, and then also feel free to review yourself. What's going to happen is with the Q&A box, I know I have a few questions already. I'll go ahead and want to be very, very respectful for everybody's time. And so if you guys have to log off, you could just go ahead and put your questions in the Q&A box. I'll go through them. And Dave has actually graciously offered to stay after about an additional 30 to 40 minutes to answer questions. So rest assured, we'll get everybody's questions answered. And if you have any questions even after this, just feel free to email me or Jane. I'm going to pull up our contacts list here for our contacts. And so I want to close with a special thank you to our speakers, Dave and Lisa, for anybody who has to log off right now to get back to work or lunch or whatever it may be. So thank you so much for sharing some great information today. And thank you everyone for participating. Please have a great rest of your day and a really safe and healthy weekend. I'll go ahead and start our Q&A review now. Okay, let's see, our first question. Kdu has asked if there's any relief for the landlord during this moratorium. I think, Dave, you had kind of gone over a little bit of that. Is that right?
Yes, I mean, the only thing I'm available that I know was available that I had come across, and again, this is not my specialty, was the FHA rule change that allowed Fannie Mae and Freddie Mac backed loans to allow landlords to defer mortgages. And thanks for the question, because I didn't say this and I can add to this. The landlord has to show that during the time they're deferring mortgage payments that they're not evicting tenants. Well, if you're in California, the California Judicial Commission has already made that mandatory. So you should be able to automatically qualify, saying, even if I wanted to, lender, I can't do it for 90 days until after a shelter of emergency is lifted. So yes, I won't evict my tenants during the period of time I'm asking for, several months of deferral on my mortgage payments. So again, talk to your mortgage broker, talk to your bank, talk to Michelle's organization. They may be able, or Lisa Doyle, I don't know, maybe you have connections too, but ask around. And I suspect, I don't know, but again, look at federal legislation that may come down the pike. We just had a $2 trillion bill that was passed, the CARES Act. There's some follow-on legislation I heard about today. At some point, I would envision, or you should write your congressmen and senators and have them have a Landlord Protection Act that models after the Payroll Protection Act. That is, if you qualify for certain potentially forgivable loans, that could be used to supplant or augment rental income that you're not getting during this crisis. So there's no such legislation yet, but it seems like they've got the template for it with the Payroll Protection Act, and they should try to do something similar for landlords. So it's a time to mobilize, time to get legislation passed.
Perfect. Okay, thank you, Dave. Our next question is, could you please explain in a little bit more detail the best approach with commercial tenants, for example, retail or non-multi-unit, on who do not pay rent? So what do we do about the commercial tenants in retail, not multifamily, who don't pay rent?
Well, again, I start from the premise that you can't kick them out if they don't pay rent until 90 days after the shelter state of emergency is lifted. So if you're looking at a 6-month time frame, what is the best way to keep an income stream going? Yes, and I don't want to give out legal advice as to the particulars because it's too granular and I don't have the statute in front of me. I do believe there's a limited instance that if you sent out the proper notice for a commercial landlord to a tenant and you accepted partial payment on that rent that was due as of the date of the notice, that it doesn't waive your rights. But again, if you start accepting rent after that, you may waive the benefit of that 3-day notice potentially. So what is the best solution? The best solution is to do a workout order, or this is actually true, across the board. Potentially, there's nothing that outlaws cash for keys as long as it's not seen as retaliatory. If somebody says, look, I'm going to go home. If you have a commercial tenant says, I'm out of business, I'm going to go out. I've got a 3-year lease. Let's say we just cut our losses and I'll pay you for the next 8 months or something, or a lump sum. Maybe you're better off if leases, Goldman Sachs projections are right, having a vacated commercial space to be able to start listing and leasing, and you can enter into lease agreements and have new tenants come in. Nothing about the moratoriums that stop you from actually entering lease agreements. The things, however, that you have to be aware of on that end, and you have to think through just 3 steps ahead, not just answering this question, is if it's not an essential business, then they can't be engaged in working at the office at this point. They've got a shelter in place. So given all the limitations, unfortunately, the bargaining power is with the tenants in this situation, but I think it's in the tenant's best interest, if they're a good tenant, for some stability, be a landlord that works with them to get them over the hump. And maybe if you have a good relationship, they'll always remember that and be even better tenants for you down the line.
Perfect. Thank you, Dave. Okay, our next question is, what is the current Santa Clara County or nearby counties that landlords have to adhere to right now? That's from Debbie.
Could you repeat the question, please?
Sure. What are the current Santa Clara County or nearby counties, like the moratoriums that the landlords have to adhere to right now?
Okay. Well, if it's in Santa Clara County, it's either the Santa Clara County ordinance that I read to you, which is ordinance number NS-9.287. I didn't memorize it. I've got it in front of me. And potentially an ordinance in your city, like in Mountain View's got an ordinance, Palo Alto's got an ordinance. So you got to look at those ordinances. Alameda County, again, there's an ordinance there that's for the unincorporated residential. You got to look to the cities. Contra Costa County, again, maybe Lisa knows better. I only found one in Concord. I haven't found one for Contra Costa County. San Francisco, I'm sure. I haven't even looked at it. I'm just sure they probably have done both for the max. So it depends upon the county, depends upon the city, and it may be both.
Gotcha. So John had asked, number one, why doesn't the county treat the tenants like Section 8 for the landlords when the county would then the county would pay partial rent basically to the landlord? And then number two, when the lease term is up, is it better to not renew the lease, or is it better to go month to month?
This is actually another seminar, the second question. The first question is why not? Because Santa Clara County hasn't decided to do it. Section 8 is a federal program, and Santa Clara County would have to determine as a county that they would make funds available. Now, property taxes are due tomorrow, but right now revenues are down and property taxes may start going down. People are not going to pay. Counties are hurting to balance budgets right now, so they're really not in a position to be really flush. I think the realistic solution may be federal rather than local. As to the second question, if it's a residential tenant, I've given another seminar that Michelle had seen on AB 1482. And if you're a landlord, you know, basically, if it qualifies under AB 1482, the tenant can stay there as long as they want, unless you have just cause to evict. So is it better to go for a 1-year lease or a month-to-month? I would actually have that conversation with the tenant. If the tenant says, look, I'm working in a critical industry, I'm working as a supplier, I'm working in the pharmaceutical industry, I've got my job, I've got my or paycheck coming in, you're doing the tenant a favor by giving them that certainty. I should mention, you just mentioned Santa Clara County. One of the things that I saw in LA, which was interesting and maybe something you may begin to see again as these moratoriums expire and are renewed, are rent freezes. So in LA, they freeze rent at the rent levels for 60 days after the local emergency is lifted. They don't go by the state emergency. Mayor Garcetti issued a local emergency, and for 60 days or after, you can't raise the rent. So in these times, you know, you might want to give them a discount for 3 months or 4 months and a 1-year lease, and then have it ramp up as we get our 3% and 4% growth rates that Goldman Sachs is predicting, that Lisa presented. Work with your tenants. If they're a good tenant, give them a 1 year. If you don't think that they're a good tenant, it is basically one, you know, month to month potentially as holdover tenants, as long as the holdover provision doesn't violate AB 1482. And again, keep in mind that that under AB 1482, if it applies, you have to come up with just cause to evict.
Great, thank you. Brian is asking, how do we handle signed leases where the move-in isn't until May? The tenant is currently asking to cancel and does not like the lease terms that the tenant was originally responsible for. And so basically, what do they do in terms of, I guess, lost rents, you know, for a previously signed agreement?
Okay, this is a good question. I don't have a ready answer. I can tell you what the answer isn't. The answer isn't look at the ordinances that are in effect that we've spent this hour talking about. Those deal with existing tenants and existing lease arrangements. They don't deal with prospective tenants. So in the absence of any moratoriums that address that issue, it would be an ordinary contract situation. However, you know, so whatever the breach may be for not turning it in, you could look at it, although again, you'll have to wait. Well, you could theoretically file an ordinary civil action sooner than 90 days after the state of emergency is lifted and determine what your damages are. But the tenant might say, look, I wouldn't have been able to pay you, and I would have asked for rent forgiveness during the period of time until you sued. And you as a landlord might have been able to mitigate and try to find somebody else. Who knows? So I would like to see the lease. I don't want to get too into the weeds here because it's a lot of variables. I can just simply say that the ordinances don't address that situation that we've been talking about today.
Great. I just want to reiterate because I have a few questions, a few people who are asking questions regarding the slides. They will be sent out, and also all of the samples that Dave had mentioned earlier in the slides will be sent out along with a recording. So no worries on the slides, we'll get them out to you. Next question is, how will residential tenant repayment programs work in the city of San Jose?
You know, I had the cheat sheet on that. I do believe that they had provided for some method of repayment afterwards. But I don't have it in front of me. You can send an email to me. I'll look it up for you. I don't have it at my fingertips. I'm sorry.
Okay. Desiree is asking, do you have any solutions for small business protections for payback repayment plans or missed rent? So I think we kind of gone over that with the CARES Act. Is that right?
Yes, although again, the payback in terms of, I assume that the question means if the tenant hasn't been able to keep up, how do they catch up after they've deferred their rent? Is that the question?
Yeah. Do you have any solutions for small business protections for payback repayment plans for missed rent?
Well, there's different kinds of protections. There may be protections afforded by the ordinance that you're in terms of a period of time where you are not subject to eviction if you follow the local ordinance's payback procedures. Again, Fremont had some odd provisions that I thought were uh, very pro-tenant and some were pro-landlord. But one that I think is a win-win, even though the landlord may think, well, gee, I have to wait, is that Fremont allows commercial tenants that are $8 million or less in gross receipts per calendar year to pay about half of the rent that's due within 90 days, and I think the other half in 120. So there's a payment schedule that are being built in. Los Angeles, I think, again, for at least for residential, I believe it's up to a year, and maybe for commercial as well. So there may be in your local ordinance or city ordinance or county ordinance a ordinances that in effect that look at the day after on how you make payment in terms of protection from trying to get money. That's federal legislation potential.
Okay, perfect. Oh, here's a good one. A lot of these ordinances and just regulations change just sometimes weeks or days at a time, right? And so one of our guests are asking if we can have a follow-up presentation about 30 to 60 days out. I think that'd be a great idea. Dave, what do you say?
That'll be terrific. Maybe next week.
Yeah, maybe next week.
So
we'll keep everybody posted.
Yes.
Yeah. Okay, so next question. How do I find out if the city of Cupertino have passed any local ordinances?
Go to the Cupertino website. I can tell you that in researching for this presentation, all you do is go to the homepage and it's right front and center and most of the particular page. But if there's something there, the counties know that this is, or the cities know this is top of mind, and it's relatively easy to look at it. If you can't find it immediately, then you should, look at, do a little bit of a search on the site, or even there's a little local articles here and there about ordinances that have been passed, even if it's in a patch or a Mercury News or somewhere. But most of the websites are user friendly, and they want landlords and tenants to know about the rules so that they're followed.
Okay. Next question. I have a tenant in Sonoma who has lost her job and her husband has cut his hours 50%. We have indicated we will be accommodating. Should we just wait and see what the tenants have in mind? They have been excellent tenants. What is your suggestion, Dave?
Well, I don't know. First of all, is there an ordinance in Napa? I don't know. Is there an ordinance in Sonoma County? I don't know. There's the governor's executive order. So first of all, you need to see what you're required to do if they try to exercise tenant rights. But if it sounds like you're trying to be friendly, and if they ask for some level of discount or deferred payment, do an amendment. As long as it's, I can't see how that would be a problem. Again, the relationships here are important. People are getting hit that would never have been hit before. People that are never been credit risks are now unable to make payments. So work with them, but also look up to see if there's any ordinances that guide you in what you can do, and you can always do something by agreement that's more favorable to the tenant within those parameters.
Okay. Casey is asking if the rental lease is up, is it considered as an eviction according to the governor's directive? So that's kind of into the rent control laws that we were talking about.
That's an AB 1482 presentation. It may also, again, involve whether there's a rent stabilization or rent control ordinance already in effect prior to September 1st of 2019, or if an ordinance was passed since then where the local jurisdiction says it's more tenant friendly than AB 1482. That's another seminar.
Okay. Could a commercial landlord go after a tenant's personal guarantee?
Oh, good question. Good question. If the issue is, depends if you need to get possession. If you need to get possession first, that's subject to this 90-day hold. If for some reason the tenant abandoned the property, went out of business and quit, you could file a normal civil action against the personal guarantor and not be subject to the 90-day hold after the state of emergency is lifted. So it depends upon whether it's possession or um, trying to be made whole in the rent. Unlawful detainers are primarily about possession, or really that's what they're about. Secondarily, on the ability to collect or get a judgment against the tenant for back rent. You can't go more than 12 months back on a 3-day notice on a residential lease to try to collect back rent. Usually the pursuing the guarantors is a secondary action after you've got a judgment. You can then try to pursue the guarantor separately to collect.
Gotcha. Okay, next question is regarding residential tenants. So the residential tenant's lease ends uh, June 30th this year. If he doesn't pay rent for April, May, and June, can I get a new tenant starting July 1st? And
No.
then no, okay.
No. I mean, the whole idea is unless the tenant abandons the site, you can't, let's assume that the tenant stays and he's not going anywhere. And it depends again what jurisdiction you're in. If they are able to get rent deferral under their local ordinance and documented it, that's not a basis for eviction, first of all. And if it's subject to AB 1482, you can't, lease terminations on leases don't matter anymore from the tenant's perspective if unless the tenant doesn't want to renew. Okay. So you're stuck with that tenant. And even if you said, I want a new tenant, you can't get a tenant in there unless you evict the tenants that are there that stay there. You can't evict the tenants that stay there until at least 90 days after the state of emergency is lifted. So there's no self-help unless the tenants that are there voluntarily abandon it, relinquish the lease, give you the keys, maybe do a cash for keys. But you got to be very, very careful in these times. You could slip off the wrong end and they could come back and say, gee, we were pressured and we didn't know we could stay. We didn't know we had a rent deferral. You didn't give us notice and we would never have left. And so you've interfered with our lease. And so be careful, think long-term.
Great. Are there any additional resources available to landlords for relief other than the SBA loans currently being discussed?
I don't have anything at my fingertips. I would say that's why I suggested call financial advisors, call the banks, call your SBA officers locally, call your congressman. I think it's going to need more legislation. And in terms of statewide, again, I'm not seeing it, although, if the legislature does get its act together and you get your rental housing association to lobby Sacramento and have all the stakeholders at the table coming up with solutions, there are win-win solutions that should include financial incentives. And I could see a situation where, that to streamline it, that the landlords get the money as opposed to giving the money to the tenants, and the tenants may not give it to the landlords. A lot of crazy things. So look for legislative solutions. I'm not aware of anything else in the marketplace as of now. Doesn't mean that there aren't any. Ask around.
Okay, perfect. Kwok is asking, how long do the tenants have to pay back their rent after May 31st? And do they pay the rents they owed in one payment, or are we as landlords need to give them a time frame to pay back the rents?
Is this Jeff Kwok?
No, it's Kwok Lau.
Oh, okay. I thought I saw Jeff. Okay. I don't have a specific answer under Santa Clara County's ordinance. I know that it expires on May 31st. So as long as the ordinance is in effect, they can defer rent. And maybe here they have 120 days to pay back. That's right. So after the moratorium is lifted, whether it's May 3rd, 31st, or some day after that point, they will have 120 days to pay. As upon expiration of or termination of this ordinance, a tenant who demonstrated substantial loss, again, if they didn't pay, if they had to document it or demonstrate it, or substantial out-of-pocket medical expenses is required under this ordinance, shall pay all past due rents from within 120 days from the date of the expiration of this ordinance. So currently it's May 31st. I can pretty well guarantee that it's going to be beyond May 31st. So take a look at it. The other things, and I think it's in this ordinance too, I hadn't mentioned, is a lot of these ordinances also say that you can't charge late fees for the delayed payment. And you can't, and certainly under the governor's executive order, And elsewhere, if you start, whether it's in the ordinance or not, some are explicit about it, do not cut off utilities. That's going to be viewed as retaliatory. So it's really a freeze it in place. If the tenants are responsible for utilities or somehow responsible to pay you for utilities as part of a CAM charge or some additional rent, and you're not getting it, don't turn off their utilities.
Okay, so it sounds like, as California it's just becoming a lot more tenant friendly and exactly that, tenant friendly in just this year, would you say, with the rent control, and now with all of what's going on with COVID-19, landlords really have kind of their hands tied. So as much as we can as landlords, I think what Dave's suggesting is basically to keep open communication channels right now and to really work out a plan and get ahead of it and try to, recoup or to get any partial rents if that's possible. Is that right?
That's right. That's
Jane,
like about it. Yeah.
perfect. Jane is asking, she says, a few attendees have said that their Section 8 tenants have not paid rent for March and April. Number one, can we give a letter of termination on a month-to-month lease? And two, how many days notice must we give?
The short answer is that's Section 8, and that's governed by federal law. I don't believe the ordinance is reached to that necessarily, but so I don't have an answer for you on that one. That's outside the scope of moratoriums. I would err, however, on the side of generally the Section 8 protections are greater than most local ordinances, but now in this era of moratoriums, to the extent that they don't exclude Section 8, I would assume that they apply and augment and harmonize with the Section 8. But again, without looking at the Section 8 regulations and where this tenant is, I don't want to offer an opinion.
Susan is asking, what is the best blanket policy for multifamily residential?
I didn't understand the question.
What's the best blanket policy for multifamily? So maybe this is regarding the rents again, like best practices for handling.
Blanket policy in that sense?
Yeah.
Okay. I would say you treat each tenant uniquely. Don't treat, I mean, if the tenancy might say, okay, I'll give you a break and therefore I give everybody else a break. There is an obligation of the tenant under most of these ordinances to minimally assert and moreover at some point to document that they're suffering income loss. But the income loss might be different. But keep in mind, before this crisis occurred, we have an inordinate number of tenants paying more than 35% of their income, their gross income, on rents. That's usually the cutoff line as to what is considered burdensome. So even the loss of one job or the loss of a few hours is substantial in light of all of the other expenses they need to stay. Buy groceries, they have other financial obligations. Maybe students or former students are paying off student loans unless they get forbearance there. So there's a lot of, you're not the only creditor, although you're probably the most important creditor because shelter is important. But try to, and I'm going to go back to it again, minimally you got to follow all of the ordinances, but if you want to do something that is more favorable than what the ordinances require for your tenants, it may be in the longer term in your best interest to do so. And you're in what we call, you're acting in your enlightened self-interest at that point.
Okay, thank you. Jeannie is asking, she lives in Fremont. A tenant notified that she is not able to pay rent in May because of the loss of the job. And legally, she doesn't have to pay until October this year. So what if she does get a job before October?
It's interesting. The ordinances, keep in mind, they've all come into effect in March or in April. We were looking forward at a crisis with an uncertain and still uncertain endpoint. The ordinances take a snapshot in time and say, okay, today, if you are unable to pay, you get a certain period of time where you can defer rent. You're looking forward in time. I would, if you find out that the tenant gets a job, I would check in and just simply say, This is, again, this is also true for employers right now, where are you an essential business or not? And if you're an essential business, are you going to allow your employees to come in? You know, this is rife with potential lawsuits. Walmart's now getting sued, and I think there's some justification where they haven't provided PPE to their employees, and they're getting COVID infected. You know, so approach it like a public health issue. And if the tenant says, gee, I still can't afford it, but they're working within the ordinances, looking prospectively, and they haven't gone beyond the time that the ordinances allow, even if they get into the job, don't jam them. Don't say, well, gee, I'm going to give you a 3-day notice now because I know you have a job. The ordinances don't allow for that flexibility. So again, keep in contact and in good faith. If they have a job, ideally, I think the argument you make to whenever this is about negotiating, you may have all these good reasons why you want something, and you go in and try and negotiate with somebody else. But if the reasons don't appeal to them and don't resonate with them, you're not going to get anywhere. I think the best argument to the tenant that gets a job saying, you really want to have a balloon payment when this is all over, that the piper's going to have to be paid. Let's make it easier on ourselves. So you have a job. Let's cut into that rent right now by getting current, or at least paying month to month, and maybe paying a little bit of it down by agreement, because you now no longer qualify. That's a great conversation. You're appealing to the tenant's best interest to have stability and not get hit with a huge bill at the end. So that's how I'd approach it.
Perfect. Kevin is asking.
Somebody from Fremont. Good, Jeannie. Thank you.
There you go. What is the best way to temporarily reduce rent without being seen as a permanent rent reduction as seen by California statewide and any local rent control?
It depends upon the local ordinance again, and I would wait a little bit. And I love that question. It's the right approach to try to work through this and not just, try to maximize or leverage short-term every dollar you can get in these trying times. But I would like to see what happens to AB 1828 and Ting's bill. If it passes, the legislature will make that decision for you. So let's look what happens. But if you wanted to do it and you can do it, you can have an amendment to your lease agreement that you would say, okay, for the period of, I just, for example, in my practice, the laws prevent us from going to court, but they've been silent on how attorneys are supposed to handle meeting, conferring on discovery issues and litigation. So normally we ask for dates for an extension of time. I got an agreement from opposing counsel to allow me to compel further answers from the 30 days beyond the lifting of the state of emergency. So you can use that as a milestone. Say, okay, we're going to discount rent for up to 30 days beyond the state of emergency, and then you have a further amendment by notice of when the state of emergency was lifted by the governor, and use that as the milestone. And that may pass muster and may not violate any local rent ordinances, but again, I would like to have you have an attorney review that to see if the ordinances would somehow conflict with that.
Great. Paul is asking for our next question. Can you discuss SBA assistance programs for landlords, for example, the disaster loan, PPP, and CARES Act? I could add to this too, Dave.
Go ahead. Why don't you address this, Michelle? Thank you.
Okay, so we could probably have a whole nother webinar regarding the SBA assistance programs. And here's what I'm finding out from a lot of my friends in the SBA lending. So I've been coordinating with just, daily check-ins for Bank of America, Wells Fargo. I'm not even sure if they have their stuff up yet, Chase. So a lot of the big banks, they are saying that they wouldn't be able to help any clients who don't already have a business checkings account with them. So a current client with them already. Now, there are smaller banks that are offering, but just to let you guys know, I would highly recommend that any landlord who has expenses try to see how you can have at least 6 months of reserves, at least 6 months at this time, just because it's a total mess out there right now on the federal level. Just so you guys know, it's the banks are basically the federal government is asking the banks to take in the applications for a federal loan, which means that the banks have to actually keep it on their books, and they're just taking applications. They're not processing anything yet. As you can tell, if you guys have gone online to apply for those types of loans, like the CARES or the disaster loan, they don't really ask you a lot of questions. And so we don't know what the underlying underwriting guidelines are currently. And just to give a few numbers out there, Bank of America took about 185,000 applications just over the last weekend. And that means that's equivalent to $33 billion in loan apps just over 2 days when that was open for Bank of America. Imagine the amount of banks, the other banks that are taking in applications as well. So PPP is part of the CARES Act, so that's included. So typically, you know, with the federal government, they basically said 350 billion of the $2 trillion CARES Act was carved out to help small businesses. So that includes the PPP program, which basically says we're probably completely filled up already. You know, that's last weekend, it's already Thursday, and Bank of America already took in 33 billion. So I think probably by this weekend, we're going to fulfill that 350 billion. So I just, you know, I don't want everybody going out there kind of hoping that they're going to get that money right away, because it's going to take the government some time to process, the bank sometimes to process. So really a 6 months plus reserve on survival is key here. Okay. Should I go to the next question?
You asking me? Sure, absolutely.
Okay. Send me the so we'll send out all the links. So Dave and I will coordinate, and then we'll get all the links out to everybody. There's a few questions. What if a tenant decides not to pay rent, or just to pretend that COVID-19 is causing them not to pay rent? What actions can a landlord take?
Very good. Yeah, this goes back to what most ordinances require: documentation. And again, because it's going to sound like many people here are too young, they don't remember record players, but the expression is, I'm going to sound like a broken record. I'm going to go back to the same groove over and over again. You can't do anything about it if it's a rent issue for at least 90 days until the state of emergency is lifted by Governor Newsom. In the meantime, if they haven't documented it, in theory, and they refuse to document it, you can go ahead and give a 3-day notice to pay rent or quit. Potentially, you can give them a 60-day notice of termination or something if it's not subject to AB 1482. Great. This is what I went to at the beginning, but why would you? You say, okay, you pound your chest. I've got the 3-day notice, and they're snubbing their noses at me, and they're not paying me. Well, you got to wait and not take rent for all those months until 90 days after the state of emergency is lifted, and you're not going to be very happy. So what can you do? I think, again, this argues for trying to work through something with them. If they don't refuse to give you documentation, when you get to court, and I haven't talked about this because it's so far out, but if you go to court and they say, well, gee, I had COVID-related issues, in the jurisdictions where they were entitled to deferral and gave you notice it was COVID-19, the burden may be on the landlord to assume that they're telling the truth, because if they come up with the documentation at trial, and they say they gave it to you at the time the rent was due, whenever that may be, depending upon the ordinance, if they give it to you at that time, they're home free. Nothing's that clear, but then you go to trial, and I would, represent the landlord. Then the tenant comes in with all of this documentation, says, hey, I texted it or emailed it to the landlord, and they prove that up, that they had documentation that was COVID related. So after all this effort saying, well, I didn't believe them, the judge might disagree, or they can get a jury trial and an unlawful detainer, and you got 12 jurors there that have all been through COVID-19, and tenant gets up. Are they going to believe the landlord that's now asking for $30,000 or $40,000 in rent, or the jurors that are likely to be tenants themselves or have to live paycheck to paycheck? Which side's going to win? So you got to think it through. If you be aggressive now, it could bite you, and you got to be prudent. One other thing I didn't mention in the hour that I should have, although I touched upon it, these moratoriums are addressing the issue of rent, and most also deal with the issue what's called no fault evictions. There may be instances, and I may have said this earlier, I apologize if I'm repeating myself here, but in terms of what can you do? Again, if somebody is engaged in some other material breach of the lease, if there's some other non-monetary breach of the lease, oftentimes it could be a public nuisance or criminal activity, you can begin documenting that, and you can then go into court when the court's open and ask to proceed on that. So I've been focusing on these moratoriums because they only address non-payment of rent, no fault. If you have a legitimate good faith belief that they violated some other term of the lease that's permissible as just cause under a just cause ordinance or AB 1482, that's certainly subject to a 3-day notice and perhaps an opportunity to cure. But again, you can't forcibly remove them for some time.
Okay, Susan's
After a
asking,
judgment.
thank you. Susan's asking, we have a commercial tenant who has changed the locks and will not give the landlord a key. Material or structure changes are prohibited under the lease. What to do here?
Okay, well, I'm going to assume that the tenant, the landlord has a right of access under the contract. So that would be a breach of the agreement. You would send them a notice that you're breaching, we have a right to reasonable access. We want to see the premises. We're concerned by the fact that you are engaging in remodeling that may not be permitted, because right now, under the shelter-in-place order that was issued most recently by Governor Newsom on March 31st, he came out with an initial one on March 19th. We had the shelter-in-place for the Bay Area on March 16th, and then we had another one that came out more recently. But all under, and I think this is probably the Bay Area one, all residential and commercial construction is to be halted until the lifting of the emergency. And the only exception that wouldn't apply here is if you're involved in building affordable housing. So, if they're doing substantial remodeling, they're probably doing it without a legitimate contractor that would take out a permit that's not available from a county or a city building department because they're shut down. So there's a lot of things that could raise a lot of concern. Again, it may become even a public safety issue. I don't know, but you could certainly give the 3-day notice. But before I would say anything further, I would need to review it further. So you can do something. None of the moratoriums prevent you from giving notices of termination in that situation. But again, because of the California Judicial Commission's halt or prohibition on the issuance of summons for unlawful detainers, you'll have to wait a long time, absent an agreement with the tenant to resolve the situation.
Thank you, Dave. Okay, next question. This is from Carol, after you have received a partial rent, should you put something in writing for the tenant/landlord to sign? For example, state terms to repay, and also please address what and when something needs to be put in writing regarding residential rent deferrals.
Most of the rent deferrals are in ordinances that require the landlord to provide notice to the tenant. So you already have documentation as to what the ordinances require the landlord to do. That's in writing. And so yes, it's always have if you have an email relationship with your tenants, you keep the emails and ask them maybe to confirm that they received it. With respect to partial deferrals or partial rent, you should view that if they've legitimately documented, again, it's going to be tied to documenting at some point, and ideally at the time that they're asking for the deferrals, and maybe as in Fremont and in Hayward and other jurisdictions, it's required to document at the time of the request. If they've really legitimately documented that they are entitled to a deferral, you have that paper trail. The tenant has to give that to you. You acknowledge acceptance of that. And so if they pay you a partial payment, saying thank you very much, and what we're going to do is, let's say the rent is $2,000 a month, they're paying you $1,700, and so the $300 that if that's the partial, let's make it $1,000 as partial payment. So $1,000 for each $2,000 a month is, then you can send another email and have an accounting month by month with the tenant showing how much in arrearages they are. So at whatever point that local ordinance requires, they'll have a certain period of time to pay up that amount. So the tenant knows how much they're accumulating. If they pay more, then again, the amount that they owe is less. But it's a dialogue. It's an opportunity of the dialogue itself will be your documentation. And yes, it'd be ideal to get maybe PDF and electronic signatures to amend your lease terms for that short duration pursuant to that ordinance that's in effect. And again, I'm not trying to create business for myself, but depending upon how sophisticated you are, you may want to have an attorney draft something like that for you.
Perfect, thank you. So we finished all the 40 questions on Q&A, but I'm going to move to chat because I think some people had put their questions into the chat box. So Helen is asking, my commercial tenants moved out of my Livermore offices starting April 1st. What can I do, or what should I do as a landlord? I'm assuming that it's not because they, that their lease expired or anything like that. It's just because maybe of COVID.
Well, I would establish if they have formally given you back the keys and relinquished the premises, and there's no dispute about that, then they have relinquished possession, and you do have the right to relet the premises to somebody else. Whether you have a right to go after unpaid rent for the duration of the lease, perhaps, depending upon the lease terms, and then that would be deferred to a civil action. So yes, if there's a formal release, if there is not a formal release, then there's proceedings for unlawful detainers to establish abandonment of the premises. You should have other addresses for them. Hopefully, if they're guarantors, you know where they live, and just go through that process. Nothing about the moratoriums prevent you from trying to reestablish possession where the tenant apparently has voluntarily relinquished their site to the landlord. Okay.
Perfect. Philip is asking, in Santa Clara and San Mateo counties, mom and pop commercial tenants who have rent deferment for 6 months starting from April. So do the mom and pop commercial tenants have rent deferrals for 6 months starting from April? This is for Santa Clara and San Mateo counties.
I'm assuming I didn't understand the question. Are they saying that they are that the tenants that they're leasing to have the right to defer rent as commercial tenants?
Yes, that's correct. I'm not sure if
I don't know why it matters that they're mom and pop. It matters who the tenant is. It doesn't matter who the landlord is. There's no different rules for mom and pop commercial lessors versus larger enterprises that are leasing commercial space.
Gotcha.
So I'm trying to understand what mom and pop means.
I think for the SBA requirements, there was, to consider themselves as an SBA.
Okay, that
right.
Okay, that. So are they asking for deferrals on their mortgage, or are they asking for deferrals from their tenants? I don't understand the question.
It sounds like they might be the tenant in this case. And so if they are the commercial tenants, do they have the right to defer rent for 6 months starting April?
Well, I don't know if it's 6 months. I mentioned in Santa Clara County, it's 120 days for repayment after the moratorium is lifted. So it depends upon when the moratorium is lifted. Okay. And I think that's true in San Mateo County. But again, and it sounds that they're going to qualify, San Mateo County has a different definition of what a small business is. It's gross receipts of less than $25 million. So it's an actual monetary cap. Santa Clara County, as I mentioned during my presentation, refers to the Small Business Association standard sizes matrices under the Code of Federal Regulations, depending upon industry and sector. So if they're a small business under the local ordinance, and I don't have the San Mateo County ordinance memorized, so the deferral rights may be different periods of time between San Mateo County and Santa Clara County. In both instances, I certainly know for Santa Clara, and I'm relatively assured for San Mateo County, They have to document it with the landlord, just as a tenant would have to document it who's a residential tenant.
Okay. So, Philip, if we didn't answer your question correctly, just feel free to email me or Dave. I'm going to go to the next question. Helen is saying she has residential rentals in Antioch, Contra Costa County. Does she have to give relief to the tenants?
She have to. I don't know what the rules are in those in Antioch, and what are the other cities?
Contra Costa County.
Well, okay. Well, okay. I don't know what the Antioch, I believe, is in. I guess it is in Eastern Contra Costa County, isn't it? So I don't know whether there's an ordinance in place in Antioch. As far as Contra Costa County is concerned, as of last week, and I didn't check last night or last couple of days, I had not seen any countywide ordinance in place for moratoriums. So assuming, and I could be wrong, but assuming Antioch and the county doesn't have any moratoriums in place, if they give you at least notice within 7 days rent is due under the governor's executive order, that they have suffered losses within the criteria set by the governor's executive order that I mentioned at the beginning of my slides, then yes, you have to grant them relief. And one of the things, again, this goes beyond the presentation, just guessing about this. We're now in April. Michelle, we agreed to move up this presentation because I thought people might now suddenly be getting these notices from tenants because of the April rent that's due. There may be a learning curve. There's presumably a learning curve. So people hearing information from tenant advocacy groups or from other sources may not know about these moratorium. And so in May, they may pay their full month of rent in April, but what happens in May, they do it for the first time then. I would think, again, these are not, it's not use it or lose it. It's use it when you can prove it and do it right. So in May, if they suddenly give you notices under the executive order from the governor because there's nothing in place locally, you got to honor it.
Okay, great. We do have quite a few questions left. I know we're about 37 minutes into our past our hour. So let's try to get as many of these questions answered, and then Dave and I will connect and probably email out a very short response for any additional questions. First one is, I'm sorry, let's go back here. Okay, Dan is asking if an original contract says you have to give a written 60-day notice via email. With a new way of communicating, is a text email or email a valid way to give notice, or do I have to follow the original contract of over 3 years ago?
Without looking at the leases, I can't possibly answer that kind of question.
Okay.
I'm sorry. I'm not gonna render an opinion without seeing it.
Okay.
I would think that there's, as a general rule, it is best, and I advise my clients generally, without the specifics here, is if there's a more informal way of doing it, you're better off doing it formally. And the best way ever is to have a registered process server hired to serve the 60-day notice, because a registered process server in court is presumptively given a presumption of the law that the service was effectuated. That's their status. So the point of getting notice is, A, were you entitled to do it? And then B, did you do it right? And there's even rules now for residential leases as to what you need to put in the 60-day notices. And now with AB 1482, you may not be able to give 60-day notices if they're subject to AB 1482 or their own local ordinance. So whether you can even give it is itself a gateway question. But assuming all of those things are not at issue and it's only about how you serve the 60-day notice, I would say hire a registered process server. They're performing an essential service, and you've got the documentation. But again, and I don't know what this is probably early in the chat, maybe before I was talking about approach this pragmatically. Would you rather have some rent rather than none for the next 9 months or 8 or 9 months? Okay, that's the question.
Thank you. Next question is, when signing in a new tenant, are there additional safety measures to take as they may lose a job and claim COVID protection?
Well, there's maybe the question behind the question is very interesting. I think as a matter of public policy, um, even if local moratoriums have explicitly said that the provisions of the moratoriums cannot be waived by mutual agreement. You have that in AB 1482 right there. If somebody's subject to AB 1482 for rent stabilization and caps, if it applies, you can't negotiate that away. So if you're talking about additional protections like, okay, I'll only lease it to you if you promise me for the next 60 days you don't claim rent deferral, that's a violation against, if not the explicit rules, certainly the spirit of the rules, and I wouldn't go down that path. So again, the point here is to provide housing. Michelle, yes, it is tenant friendly, but I go back to my earlier point that the public policy interest that's being advanced is, yes, in part to satisfy tenant advocates, but the larger one, the better public policy reason that I think courts will grapple with in trying to interpret these rules, if it's not explicitly stated, is what is in our best public safety interest. Because, and I hadn't said this before, I was talking to a tenant advocate that I respect greatly. I said, um, why are you so worried about whether somebody can give out notice of termination or not? Because they can't get to court. And that was even before the California Judicial Commission put a 90-day hold. And he made a very good real life response. He says, tenants are not always informed and they're intimidated and they're scared. And so if you give out a notice of termination, you might just scare a tenant to simply leave the premises not knowing what their rights are. And so I'm not encouraging that at all. But again, if they find out later that they had a right to remain there and you didn't give them the proper notice in your termination notice and they left, there are potential tort actions that already exist under common law. Violating their right to constructive quiet enjoyment is a covenant that's implied in all leases. And again, in the city of Hayward, if they didn't comply with that ordinance, you could be looking at lawsuits and perhaps injunctions. And given the litigious nature that we're in, if there was a series of tenants and you had a large apartment complex and you did this to 30 or 40 tenants, they might even file a class action against you. So be very, very, very careful. Err on the side of bending backwards in compliance. If you think you're going beyond compliance, you're on a lot safer side of the road than trying to cut corners.
Okay. Eugene is asking, I have a townhouse in Mountain View. I'm afraid that after the renter is not paying rent for 3 to 5 months, and then I only have 1 month of security deposit, does this mean the tenant can just walk away and I don't have any leverage as a landlord?
You don't have any leverage to collect the rent if they walk away. You always have the potential, if they're renting a townhouse in Mountain View, they may be engineers or have some good income. I mean, it's very high. Presumably anywhere in Mountain View, you're getting fair market value for the tenancy, and at some point they were able to pay, 2,000 or 2,500 a month for the townhome. Who knows? Um, the leverage would be to file a subsequent civil action and try to collect the past rent as an ordinary contract action. And if they're going to look for other places to stay, yeah, people are going to have, um, some legitimate reasons so that they don't get dinged in their credit. But these are people that are going to be that are going to probably want to look for somewhere else to live in the Bay Area, so they don't want to have this over their shoulders. So you can't retaliate. You can't do anything that would violate the ordinances in the meantime, because that would subject you to liability. But if they do walk away, your leverage is to apply all, after you do the deductions that you're required to do for beyond normal wear and tear. If you're authorized to do so under the lease, apply the balance to the lease payment that's due, and then sue for the difference as an ordinary contract action and seek attorney's fees, because if it's in the contract that allows you for attorney's fees.
Okay, thank you. Stephen is asking, he has the current purchase transaction in place, and the seller has already given notice to the existing tenants to move prior to shelter in place. Can the seller still be able to evict the tenant during this time, especially when the tenant has not paid rent to the seller for over 3 months?
Well, I guess I haven't done a good job in talking about the California Judicial Commission. I've said this about 6 or 7 times, so maybe I'll give the benefit of the doubt. It was early on and they were listening to their question rather than my presentation. You can't do anything. The courts are closed for 90 days after the shelter of emergency is lifted. So right now, I gave the hypothetical that the the state of emergency is closed at least hypothetically until November 1st. When we have we hit the apex, we're flattening the curve, we're getting COVID-19 infection rates down to a level that we can return to our economy. We have to have tests in place to determine who's had it, who's symptom free. None of those things are in place. We don't have the infrastructure yet to be able to even begin to measure when we're past it so that we minimize the chance for a rebound effect. And right now, Wuhan just opened up again, and they're concerned that it might have a second round. So we got to look at the long haul, and I'm expecting that the governor, based on public health officials, is going to err on the side of public safety as he's done so far. And the California Judicial Commission is not going to budge, and it's going to be a moving 90 days beyond September 1st, October 1st, November 1st, whenever that emergency is lifted. It's 90 more days before you can even file your lawsuit, and then it's another potentially 2 to 3 months thereafter before you get a trial and judgment and eviction. So can you do anything? No.
Okay.
Except let me have this. It's it's dangerous, and I don't want you to try it and be overbearing. If they really want to leave, then you can do a cash for keys and stuff like that. But it's dangerous right now. They may be saying, "Look, you pressured me. It was under duress. You didn't have a right to do it." Try to work it out if you can informally, though.
Thank you. Next question is by Jennifer. She says, it's a bit off topic, but given the current COVID-19 restrictions, can a landlord ask tenants to allow buyers into the property to view it?
Ah. Wow. It is off topic because I don't think you can. Oh boy. I think that's an excellent question. I don't think um, if buying and selling property is not an essential activity, and I would start from the premise that it isn't. It may be essential to you to try to make money, but it's not. You're not part of the supply chain for pharmaceuticals or for groceries, or you're not a first responder. Um, you could maybe informally allow it, but I would not, if they say no, I don't think there's any basis for you to require access for that purpose. Now, if there's a public safety issue, if the maintenance issue, and there was something that was leaking into another floor, plumbers are essential, providing an essential activity, you could demand access. If you like at a 2-story apartment complex and the toilet was flooding into the first floor, that would be a situation where you could have access. But for
Dave,
yeah,
actually, a few of our attendees, and they're saying that real estate professionals, in terms of realtors and brokers, they are part of essential services.
they are.
Yeah, they are.
Okay.
Mhm. So with that said, do tenants have to allow?
But I could see that if you're listing something and the homeowner consents to listing and the homeowner is trying to sell, sure, you can have your open houses. I think that's slightly different than a tenant who is there and has somebody that may be COVID infected coming into their premises and wandering around. Creates a different set of issues. So I don't, what may be essential in one situation may not be in another. I would ask, thank you for that feedback, and that's great for the iterative process we have here. I would ask the public health official for the county that you're living in for some guidance and see if there's any rules on that. And I would talk to your county supervisor, or if you're in a city, a large city like San Jose or Berkeley that may have their own public health officials, email them and find out what the guidelines are.
Right,
That would
so
be the best
actually,
answer.
we have Tim who says, I am the government affairs manager for the Association of Realtors, and they are essential services, but private showings cannot occur if the residence is not vacant. So thank you, Tim.
So that's the answer. Good.
That's the answer.
Good. So the answer is no.
That's right. Thank you. Okay, so right here, let's see. Can the landlord not pay the HOA fees in the meantime since he is not receiving any rent? These are some great questions.
No. The answer is no. The relationship between the landlord and the HOA is independent of the landlord and the tenant. There's no by. I've done some work for on behalf of HOAs, and I've never seen a CC&R bylaws that say in the event of a pandemic and you're not receiving rent from your lease tenant for your HOA condo, you're relieved of paying HOA dues. The answer is no. You got to pay your HOA dues. Now, having said that, normally a lot of HOAs have some restrictions on the number of units within a planned unit development that can be leased, sometimes 25%, whatever it is. But there's people that are living there and tenants that are all going through the same COVID-19 setback. So it may be a motion that you would make to the HOA to ask, hey, do we have enough reserves here? Can you give us 3 months deferral, and have the HOA pass a resolution and organize with other owners to show up at a board meeting, or at least not show up, but whatever they're doing for the board meetings by Zoom or WebEx, and make that by agreement of the HOA. That would be the course I would suggest doing.
Thank you. Ming is asking, is it legal for the state to set all of these new ordinances against landlords? A lot of landlords rely on the rental income for day-to-day life. Even if you delay the mortgage payment, there are still other bills such as property taxes. Resolving one problem at the expense of landlords could create other catastrophic situations.
The answer is, I'm sure it will be challenged at some point. I think right now we're all in pandemic mode, and I think that there's kind of we're all to be concerned about safe distance, social distancing, washing our hands, wearing masks now, doing all the things there because our lives are at stake. That should be the first concern. And that is a concern that undergirds the authority of the governor and by extension the counties to exercise these enormous emergency powers. And in the exercise of public health and safety, all of our rights, our property rights, are subject to balancing tests with the courts. And so, yes, we have a right to avoid unlawful takings by our government. Is there a due process violation? Well, the answer probably would be in balancing the issues, no, because as of now, there's a mechanism by which rent is still owed, and the ordinances are very careful to say that there's been no waiver of the obligation to pay rent. All that these ordinances are doing is timing. Well, that doesn't help you. I get it, Mimi, if you're trying to pay your mortgage and the timing doesn't work with you and the property taxes are not getting deferred. It doesn't help you in the short term. What will be the more interesting question will be if the state, through AB 1828 or something similar to that, or San Jose, as it almost did on Tuesday night, exercises its police powers to try to implement rent forgiveness. That begins to raise more issues. And so that may be more suspect. That's why the housing and rental housing groups are so up in arms. And I can understand that because you'll never get the money back by law. You can't collect it. You won't ever get it back. That changes the balance between the rights of the property owners and the rights to public safety so far in favor of the tenant in that balance that may be subject to a challenge as being unconstitutional.
Okay, thank you. So we probably have time for about 2 more questions. So one, can a commercial landlord ask for bank accounts to prove that a tenant cannot pay rent?
The commercial landlord is restricted to what the documentation is that a tenant can provide, and these ordinances typically provide for examples. In fact, the one I gave you for the tenant form for Santa Clara County, although even if it focused more on residential, it's applicable to commercial small business tenants. If they provide any of the documentation, and it's not bank accounts, but other documentation such as that is permitted, something that shows a loss of receipts or they've had their business closed, um, then um, then the landlord is duty bound to rely on it if the ordinance provides other means by which the tenant can document a substantial loss of income. Um, Interestingly, and this I only saw in the the Fremont ordinance for small businesses requires the tenant, if they're a retail establishment for food, to show that they're doing workarounds like pickup and delivery, that they're trying to mitigate their loss of income. But that was the only ordinance I saw, and all of the ordinances where Fremont tried to micromanage what a small business that earned less than $8 million per year was required to show before the landlord had to give rent deferrals. So again, it depends upon the jurisdiction and the ordinance. And again, bottom line, I don't think any of them say it has to be a bank statement. If it's other things that the ordinance allows the tenant to show a substantial loss, you have to rely on it.
Thank you. Okay, so our last question, and I'll be sure to go over the other questions that haven't been answered with Dave after this, but just for the sake of our webinar, our last question for discussion would giving one commercial tenant a discount automatically qualify other commercial tenants the same if they claim similar hardships, or could different amendments be worked out for each tenant?
Absolutely, it's tenant by tenant basis. So there's no, I mean, obviously the commercial tenants might talk to each other and kind of, educate each other as to what they did to justify it. And as long as the other tenants submitted documentation, you're probably required to accept it if they talk to each other. However, if you have a business that is, um, if you have a small mom and pop grocery store that is still allowing for pickup or people to shop next to, and maybe next to a dental office that had to shut down except for emergency appointments, those are two different kinds of business models. One's going to be more severely impacted than the other, so there's got to be a little bit of common sense. But this is where you get into litigation. If they provide you documentation, you're not to be judge and jury, because if you think, well, this is fake and it's fraudulent and you're wrong, then you're never going to be able to evict them once the court is open. So, um, but to answer your narrow question, no, you don't have to give a cookie cutter discount to every or deferral to every commercial tenant just because one asks. Each has to be separately initiated by each commercial tenant, and each circumstance should be different.
Okay, I actually scrolled down to the very bottom. We actually only have one question left, so if we can answer that, that'd be great. So Sierra is asking, we have a tenant in Orange County who has stated he has not lost his job, but he has a tenant in Las Vegas who cannot pay their rent. So therefore, he is seeking to have his rent deferred for the next 3 months because he knows of the mortgage forbearance, and so he wishes to keep his cash in the bank. Is this an example of someone who we can still require to pay rent since he has stated he did not lose his job?
I didn't understand the second part of the question, which is that he has to keep cash in the bank in order to qualify for mortgage forbearance for his house in Las Vegas. That seems a little bit attenuated.
No,
He can afford.
sorry. Let me reiterate the question. He's seeking to have his rent deferred for the next 3 months because he knows about the mortgage forbearance, right? But he also wishes to keep his cash in the bank. So he's requesting a deferred rent for the next 3 months. So
Okay.
can they
Those
still
are two
collect?
different things.
Mhm.
The mortgage forbearance that I was aware of, and again, there may be other products that I don't know about, only dealt with a moratorium on evictions for non-payment of rent. It didn't deal with deferral. So, so when you're dealing with the FHA, the Freddie Mac, and Fannie Mae, they're only saying, please, during this period of time, make a promise that you're not going to evict anybody. And every landlord in California can do that because the courts are going to be closed for so long. Okay, but that doesn't replace the obligation of the tenant to comply with whatever local ordinance may be in place in Orange County or in the city that you're in to document that he in fact has a substantial loss of income separate and apart from the ability of the landlord to get a mortgage forbearance. If he cannot document a substantial loss of income, personally because he's got his job, then no, he doesn't qualify. He's not eligible for rent deferral. If he refuses to pay you, sure, you can give him a 3-day notice. And again, you go back to, how difficult this is going to be. So he can leverage the situation. But as long as he doesn't meet the eligibility requirements under any of the ordinances that apply for your property, Orange County, the fact that you have mortgage forbearance as a landlord does not give him a get out of jail free card.
Right. So even if he's just wanting to keep the cash, even though he has money to pay currently, he's still able to technically defer on his rent payment.
Defer on it, but again, if he's keeping the cash, there's no guarantee that in 90 days after the forbearance is lifted, he still has the cash, and then he's behind. So the idea is to keep the income stream going for ineligible tenants that do not have a substantial COVID-19 related loss of income and minimize the impact to landlords in this instance. There is that balancing so that only truly eligible tenants under these ordinances should get the benefit of these moratoriums. Okay.
Thank you so much. Okay, so we are a minute over 1 o'clock. Thank you everybody for your participation. We'll go ahead and get all the slides and information out to everyone. Andrea, I do see that you submitted a question. I'll touch base with Dave and then email you directly. So send me your email if possible. Thank you everyone again, and we will get back in touch as soon as Dave and I put a date on the next update.
Thank you. Thank you, Michelle. Thank you for everyone participating. This is very exciting.
Thank you.